Hello, everybody. I'd like to welcome you all today to our session. I'm Catherine Macmillan. I'm a professor of private law at King's College London, and I'm also a senior research fellow at the Institute for Advanced Legal Studies. It gives me great pleasure today to be able to chair this session on disallowing legislation, colonial rule of law, and continuities of illiberal power by Professor Hakeem Youssef. Now, by way of introduction, for those of you who aren't familiar with Hakeem, he is a chair in law and global studies at the University of Derby. He's also a barrister and solicitor of the Supreme Court of Nigeria. Hakeem's research interests are in transitional justice, comparative constitutionalism, and economic and social rights. Hakeem's work in transitional justice has won international recognition. In particular, his first book, Transitional Justice, Judicial Accountability and the Rule of Law, was shortlisted for the inaugural Kevin Boyle Prize 2011 of the Irish Association of Law Teachers. In 2011, Hakeem served as a Commissioner of Truth and Reconciliation Commission in Osun State, Southwest Nigeria. His second book, Colonial and Post-Colonial Constitutionalism in the Commonwealth, Peace, Order, and Good Government, Routledge 2014, was awarded the prestigious John T. Saywell Prize for Canadian Constitutional Legal History 2015 by the Osgood Society of Canadian Legal History. He is the first non-Canadian based non-Canadian to have won the Saywell Prize. And this work was a precursor to his current research on disallowance of legislation, his topic today, and it forms a part of his interest in colonial legal constitutional history and its contemporary legacies around the world. His current research is being presented at this webinar, is investigating the past, present, and future of the power of disallowance in an age of decolonization, liberal democracy, participatory governance, and human rights. The research examines how the power of disallowance has shaped the construction of law, contemporary lawmaking, and administration of justice in 6 countries and territories: Australia, Canada, Gibraltar, Hong Kong, Nigeria, and the United States. He hopes that the book that culminates from this research will be the first cross-continental comparative and socio-legal research on the theme. Now, Hakeem has asked me to stress that at this point, he has more questions than answers on this topic. And so he very much looks forward to your comments and also your questions with regard to his paper today. A little bit of housekeeping before I give the floor over to Hakeem. The digital age has changed the role of the chair for these sorts of proceedings. If you could, you will find in Zoom that you have 2 sort of boxes where you can write things. One is a Q&A box. You will find this at the bottom bar of your Zoom screen. If you have a question for Hakeem, please put it into the Q&A box, and we will rely upon this rather than calling upon people after the talk for questions for Hakeem to address. If you have comments that you'd like to raise in the course of the discussion or perhaps afterwards, please do put these into the webinar chat box. So without further ado, I'd like to turn this, I suppose, virtual floor, as it were, over to Hakeem. Please, Hakeem.
Thank you so much, Catherine. I can't thank you enough for agreeing to chair this and your personal enthusiasm and interest and encouraging words in our interactions previously leading on to today. So let me thank us all for trusting me with up to 1.5 hours of your very valuable time this afternoon. As Catherine said in that introduction, this work is stemming from my turn in research in the last few years to the legacies of colonialism as regards how those legacies have been shaping, shaped and have in sometimes not so hidden ways, surprisingly, developments in the Commonwealth as currently constituted, and even beyond, because I'll be talking briefly about the United States. And in fact, this has a lot to do with the United States, sometimes more than even countries now that are recognized as part of the Commonwealth. But to just throw that out there, today it will be very strange to talk about the United States as a Commonwealth country. But it started out being probably the chief Commonwealth country, as it were. And that's why till today, a few states in the United States still use the Commonwealth of Kentucky and all of that for their as part of their official names. But so much for that. I recognize the United States isn't now for centuries not being formally part of the Commonwealth. But this work has stemmed from my examination of the peace, order, and good government power in the Commonwealth, on which I have written the book that Catherine has mentioned. It's part and parcel of very important constitutional devices that are flowed from empire, from the British Empire as constructed. And I found it quite interesting, intriguing even, that some of these constitutional stratagems, provisions, and stuff that were very central to organizing the colonial rule have found their way to post-colonial Commonwealth. And that I find, to the Commonwealth, that is post-colonial empire. And that has been a theme that I've found quite interesting. So that is the background to this work. So the outline basically today, I'll probably speak for another 40 minutes. I hope I won't bore you, is as follows. What is disallowance? What's all this about? Why am I interested? Why is it something of interest or importance? And then I will look at the role of law itself generally in the process of colonization, what I call the Colonisation Enterprise. And then how do we make sense of the application of this power of disallowance, essentially at this point, at the initial stages of my research, where what I've looked at so far is essentially the application of the power of disallowance in the colonial context, which is the starting point as to how that has shaped things. So making sense of that. And specifically, I will be talking about Canada. So I'm looking at least 6 countries and territories, like the chair had mentioned. But for the fact that Canada, both in relation to my work in peace, order, and good government, and now on disallowance, is a prime jurisdiction to look at. It's probably the classical jurisdiction to look at, even though the application of the power did not start there, but it's the classical one. And also for contemporary reasons, I'll be talking briefly about the application of that power in Canada and where is it today in Canada and beyond. So where should it be? So my whether disallowance is a rather poetic use of it, whether in the sense of questioning whether it should continue, and whether in my instinct that actually it shouldn't, so that it should wither away, but it is not withered yet. So when we get to that, we'll see, and then I will conclude. Actually, look out, my conclusion is going to be with questions which I would like for you to contribute to, because I am probably still 2 years plus away from concluding this research on my book at all. So what is disallowance? Basically, disallowance stems from the idea, or from a concept that is known as the royal disallowance. What I'm referring to as disallowance in this lecture stems from the royal disallowance. And the royal disallowance is the power of the king or the queen that is of England, the British monarch, to review legislation made in any of the colonies. And that power is derived from something known as the royal prerogative, which Commonwealth scholars and British constitutional law scholars are very much aware of. The royal prerogative basically is the remnants of the monarch's power. So the monarch had absolute powers previously, and after a while, as we know, in the constitutional and political and constitutional development of England, the monarchy's powers became limited. But there are certain powers that are derived from the days of absolute power of the monarchy, and that is in a very simple form is what is known as the royal prerogative. It covers quite a number of things, and it's still important, even though it has receded in significance, but it's still important and it's still there till today. And in terms of a definition, I find it very useful to rely on the work of Charles Andrews. By the way, this is a much neglected area of constitutional or legal constitutional scholarship, and most of the references I have are old references. Like I said, that speaks, I'm out in any event also looking at the historical development of the power at this point. So Andrews says that it's an act of regulation and control, one of the means employed by the king or the queen, as the case may be, through the Privy Council to confine the colonial legislatures within the constitutional bonds of their powers. That's what Charles Andrews says in this paper. I have a brief reference list for the most important references that I've used at the end of my slides after my conclusion. And this power of royal disallowance is actually one in its initial operation that Aeneas, that the crown had in relation to local legislation, if local there or domestic legislation, meaning UK legislation, namely that the queen or the king could refuse to assent to legislation that has been passed by parliament. But as far as it goes within the UK, it was last exercised in 1707 with regard to the Scotch Militia Bill. That was the last time it was exercised in the UK, but certainly not the last time it was exercised in the empire. The power of disallowance actually is not derived from UK law or English law, as the case may be. Not surprisingly, it has its origins in Roman law. So what has happened, though, is that it has been recrafted and popularized by British colonialism from the 16th century onwards, specifically with reference to the colonization of the Americas, the North American territories, today largely or essentially parts of what is now the United States and Canada. So, and then later to all parts of the empire. So it was a power that was crafted or developed for governance and administration of justice in the empire, essentially to protect British interests. Now, you will then think that with the dissolution of empire, largely with the independence of various parts of the empire, led first by the United States, that power will be one that will be jettisoned by subsequent constitutional arrangements in those countries, or at least if not immediately, but soon after. But the United States example shows us just how that is not the case. Now, consider that the United States Declaration of Independence of the 4th of July, 1776, denounced the royal disallowance. It actually had at as a major grievance of the colonists for denouncing the authority of the British monarch and demanding independence, the abolition or condemnation of the royal disallowance. In fact, the first and second counts of indictment against the king, which formed the basis of or part of the US Declaration of Independence, stated as follows: he, the king, that is, has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance unless suspended in their operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend to them. So you will then think or expect that in writing the US Constitution, the power of disallowance of a sovereign will be something that the colonists, the agitators would have been wary of. But no, actually, the US Constitution has retained the power of disallowance in form of the presidential veto. So that tells you how just significant that power of disallowance remains. It's the same in post-independent Nigeria as it is actually, as you see, even in Canada, at least to some extent. Okay? Now, why this power of disallowance? Well, I'm looking at it because, like I said earlier, it's become an important feature, or has remained an important feature of Commonwealth constitutions and also beyond. And in light of my question and interest in it is that in light of its colonial origin and contemporary experience of its exercise in post-colonial context, does the POD, that is the power of disallowance, promote democracy, or is it antithetical to democracy? Consider, for instance, in this regard, that in 2019, President Trump actually threatened to exercise that power to defeat legislation that had been passed by the US Congress. If the Congress does not make money available and funding available for his pet project, the building of a wall at the Mexican border, he actually threatened to not sign and block legislation through the exercise of the veto, which is the way the power manifests in the US constitutional landscape. So that tells us the relevance of the power, but it's quite interesting how that power is one that harkens back to the colonial context. So my interest is, if the power is one that is antithetical to promote democracy, then is there a way in which it can be enhanced? And if it is one that's deemed to be antithetical to democracy, should it be reformed or abrogated, as it were? That's what I'm hoping to, that's what I'm exploring. That's what I hope to have an answer to at the end of my research. Now, law itself as an institution has played a central role in the colonial project, because law was required to establish the order, within colonies in a particular manner that is intelligible to colonizers, to achieve the purpose of expropriation, which the colonization project was about. So law was always an important factor. So it's not then surprising that measures like the good peace, order, and good government, and also provisions like the royal disallowance were at play there, because essentially they formed part of what Lauren Benton referred to as politics of legal ordering, namely how political actors within the sphere of politics try to set up or organize arrangements in a way that would suit their purpose, that they will recognize that they are familiar with and will suit their purpose of maintaining power, as it were. And so it is also in the colonial project, namely that the primary objective for imposing colonial law here, specifically the royal disallowance, was to safeguard the interest of the colonizers. And like I said earlier, before the British had done this, the Romans had done it to many others, including to the British as well. So it's not a unique thing in its application. It's just typical of colonizers. You want to organize the colony or the sphere of influence in a way that's intelligible to you, that you can actually control affairs. But given the sheer size of the British Empire anyway, it was a measure of political pragmatism. It was required. This was something that the times, the environment, the circumstances required. There wasn't enough manpower to extend to what as late as 1900 was something that occupied about 3/4 of the known world. That's the extent. As late as 1900, the British Empire extended to 3/4 of the known world. And that excludes, at that point, the United States. Can you imagine? So it was always the case that some form of pragmatism was needed. The colonists and the colonies needed to be given some leeway to make law, but in a way that the colonizer will be able to manage the affairs, literally speaking. So, and that is why approving and disapproving legislation was a key measure for imposing imperial authority from the center, so that we know what laws you are making. We do allow you to make certain laws, to make law for yourselves at some point, and we will recognize your right to do that, basically because we can't be everywhere in every way, and we have limited resources, manpower to monitor or govern. But we would ensure that we have a sense of what is allowed and what is disallowed to protect our interest, as it were. Now, some fun facts about royal disallowance. Originally, it was not introduced actually in the British Empire by the government. It was by the Colonial Office. It was rather introduced by the chartered commercial companies. Bear in mind that in colonizing so many parts of the world, whether it is the North American territories or Nigeria or Ghana, many of these places, or South Africa, many of these colonies, or Newfoundland in Canada, many of these places were actually colonized by chartered commercial companies that were given precisely that, charters by the Crown of England to acquire those places in the name of the king. So in the history of constitutional practice within British Empire, the chartered commercial companies with their headquarters typically in London actually introduced this measure of disallowance to ensure precisely that they are able to know what is happening within their colonies. But later, so it was first introduced in Virginia and Bermuda by the chartered commercial companies that were given by the governors of the chartered commercial companies that were given the charters by the British monarch. And when the charter was surrendered in the case of Virginia and it became a royal province in 1624, the Power of Disallowance was adapted. It was adopted and then adapted in the form that the power was now vested in the crown rather than in the governance of the chartered commercial companies. And the first, up to this point that I've found, the first actual exercise of the bar was to disallow certain provisions of a legislation in Barbados in 1664. Now, what's the constitutional basis for it? Because there's a system to it all. And basically my interest here is as a scholar of constitutionalism. The constitutional basis for it has been well explained in a long quotation. Pardon the fact that I'm using this long quotation, but I find it quite apt to put the message across by Todd Alpheus. He has written that the right of the crown as the supreme executive authority of the empire to control all legislation in any part of the Queen's dominion is self-evident and unquestionable. In respect to the colonies, the royal veto upon legislation has always been an active and not a dormant power. A colony is but a part of the empire occupying a subordinate position in the realm. So that's a very important thing. Subordinate position in the realm as against the metropole, as against the center. No colonial legislative body is competent to pass a law or repugnant to any imperial statute which extends in its operation to the particular colony. Neither may a colonial legislature exceed the bounds of its assigned jurisdiction or limited powers. Should such an excess of authority be assumed, it becomes the duty, that is my emphasis, of the crown to veto or disallow the illegal or constitutional enactment. So if you break that down, a number of things are going on there. First, that the colonies are deemed to be subordinate jurisdictions in the first place. The power of the monarch is, as scholar put it, in that context, one that is self-evident and unchallengeable, as it were. And the colonies as part of the empire do not have full powers as the imperial legislature does have. All of this all these are actually basic to the composition of the composition of the relationship between the center and the colonies in the 18th, 17th, 18th, 19th century even. Okay, so it's said here that it is the duty, it's not even a discretionary issue, that it's the duty of the crown to veto or disallow the illegal or constitutional enactment. And that is one of the reasons why I find it quite intriguing that the power of disallowance has in several forms subsisted in post-colonial countries. Because then the question arises as to whether we are creating a new sovereign of the nature of an absolute monarch that the British monarch was and had not been even within the United Kingdom for more than 200 years now. Okay, so in terms of the rationale for the review also, a body that was charged with managing the affairs of the colonies is the Board of Trade, as it was known, Board of Trade and the Plantations. Now, the 1696 commission of that Board of Trade tells us the rationale. So we talked about the constitutional basis, but the rationale for the review more explicitly is to examine into this. There's of course 1699 some bit of old English here. So to examine into and weigh such acts of the assemblies and to represent the usefulness or mischief thereof to our crown and to our kingdom of England or to the plantations themselves, in case the same can be established for laws there. Now, this is a lot, but because of time, I'll just tease out one or two points from this. This is saying that the trade is reviewing laws that have been passed in those territories, in those colonies, to examine the usefulness or the mischief to our crown, namely that those laws should not go against the interest of the crown, whether in the crown in its capacity as the sovereign, or the crown in the capacity as the upholder of the interest of the of imperial interest, as it were. And that's evident, and says it's in the next clause, and to our kingdom of England, or the plantation themselves. I find this later part intriguing because of the fact that it's alluding to the fact that the plant board knows what is best for those plantations, and the subsistence of such a power then in an executive officer, a president, a prime minister, or such other individual within the current post-colonial arrangement in a democratic age is really something that I believe is worth a second look at. So we have a president, we have a prime minister who is sitting now in place of the crown and able to determine that the people's representatives are not capable or representative enough of the interest or the views of the people. Quite intriguing, that. So the royal disallowance, anyway, was the most drastic outcome of the review of colonial legislation. There was scope also for return of legislation for amendments. So I needed to just point that out to give a complete picture. But the most drastic was that the most outcome was the royal disallowance, which meant that legislation that had been passed, that had been working, that had been applied or in operation, sometimes for more than 2 years, were then subsequently disallowed, and then and whatever acts had been done under them remained legal. Then that legislation no longer operates from the point of modification of the. The next point I want to look at is making sense of the system. So what really was happening? Was there a system to it? What was being disallowed? Because this will help in looking at the current practices on disallowance to see whether there is a pattern of the application of disallowance in colonial law and today, whether there's any correlation. But first, and for this purpose here today, essentially, what was it that was deemed not to be useful or to be concerning to the imperial power in application of that prerogative of disallowance? Swinfen's work, which is a dated one now, on imperial control of colonial legislation, is an excellent resource that I found. I'm probably almost second to none on its review of colonial legislation. There are quite a number of works on the operation of colonial arrangements on law and constitutionalism, but Swinfen's work was focused on the policy of imperial control of colonial legislation, looking at the 19th century, and it provides specific insights of colonial policy as well as general trends and principles that were used to examine or review this legislation made in colonies. And this is just a snapshot of what emerged from my research on this issue of whether there was a system. Just very small snapshot here and there because of time. In Canada, like I said, Canada is a prime jurisdiction for examining this work. In Canada, in British Columbia in 1884, anti-Chinese immigration legislation was disallowed. By the way, one thing I found very striking, and I know some colleagues have actually, most recently, 2 colleagues have actually written books here in the United Kingdom on how the structures of colonial exclusion in the 16th, 17th, and 18th century, and even 19th century, are actually being replicated in the current immigration policies of the United Kingdom in the 21st century. Quite striking. Look at this. In British Columbia in 1884, anti-Chinese immigration legislation was disallowed. Okay, that's a positive one. The basis was that it was contrary to imperial interests. and in any event, it was ultra-vires of provincial powers. Essentially, the legislation was targeted at taxing those who provided transportation for Chinese immigrants into Canada in such a way that it would be commercially unviable for them to engage in that activity. It was again reenacted the next year, and it was disallowed again by the imperial government. In 1898, in the same British Columbia in Canada, two further legislation come up in my research, amongst others. One is the Tramway Incorporation Act, which sought to exclude Japanese migrants. And another is the Labor Regulation Act, which imposed financial penalties on employers of Chinese or Japanese workers. Both were protested by the Japanese government, and they were both disallowed for not being in line with the policies of the imperial government. Now, remarkably, however, so you find that this speaks to human rights. That's fine. So it seems that the application in those cases, or the rationale for it, is actually one that today, even on the terms of political developments today in human rights and all of that, were quite in order, sophisticated, and commendable. But just wait a moment then. In 1900, two further British Columbia laws only, quote, slight, and Indians were actually allowed, okay? And actually allowed. So sorry. So what is happening here? Your guess is as good as mine. Further, there is this Liquor Licenses Act in Vancouver, okay? Both legislation were allowed, with one of them being deemed only slightly discriminatory against, watch now, Mongols and Indians, not Japanese and Chinese. And I wonder whether the absence of advocates for the Mongols and the Indians at that point was one of the factors that did not make them contrary to imperial interest and for them to be allowed. But there it is, discrimination not allowed, discrimination allowed. Now, in the case of the Liquor Licenses Act and the Vancouver Incorporation Act, both of them actually denied the Mongols and Indians franchise. They were not allowed to vote. Another issue of discrimination, and yet they were both allowed. So, a system. Well, maybe not. Again, one of the dimensions, as I will talk about presently, of disallowance in Canada is what is known as Dominion disallowance. It was used to interfere with a wide range of legislation: immigration, banking, mining, insurance, sale of alcohol, public utilities, as Harlow but what were the reasons for such interference with provincial legislation? The reasons varied, but they included conflict with Dominion legislation, exceeding limits of provincial legislative competence, and interference with individuals and property rights. All positive, but compare also in the same Canada to those cases of 1900 in British Columbia. Now, let's move and see somewhere closer to where I come from, South Africa. In 1906, prior to responsible government being the government that is organized in the nature of the British political system, the legislature there enacted the Asiatics Law Amendment Ordinance. The ordinance required the registration of all resident Asiatics, and this was disallowed by the imperial government. Here, a tick, positive one, fine. But then, that same year, the country's inaugural responsible government was promulgated, or was the country's first responsible government was inaugurated, and the legislature as part of that. And one of the first laws they passed was one of the first legislation they passed was to actually bring back this same legislation that had been denounced and rejected earlier in the year by the imperial power. But this so-called unanimously passed legislation was then allowed and assented to by the imperial government the same year. And the rationale was that it reflected the general will of the colony, clearly expressed by its first elected representatives. So again, we don't know what really to think about whether there was a system to it. Anyways, going further, I mentioned that I would look briefly at Canada because for me it represents a very good jurisdiction that broadens our understanding or provides room for wide application of the power, at least to a certain point in its history. There are two forms or categories of disallowance. One is the imperial disallowance, and the other is the dominion disallowance. I alluded to the dominion disallowance earlier. Imperial disallowance is provided for in Section 56 of the Constitution Act, that is the British North America Act, now known as the Constitution Act 1867 of Canada. It authorizes the Queen to disallow any act of the Dominion Parliament. The Dominion Parliament referring here to what is now the federal government or the federal parliament of Canada, and this has to be done within 2 years of the receipt of any legislation made there. So basically, Canada is organized as a federal country where there are provinces and there's a federal government. Pretty much, well, not pretty, ostensibly to a large extent like the United States, but there are very, very strong differences in their federal arrangements. These being one of them, this power of disallowance being one of them, specifically dominion disallowance. So what it required was that after a law had been passed, the law comes into operation, but as soon as possible after it's been passed, the law is then sent over by the Governor General to the Imperial Parliament, that is the Parliament in the UK, and it's sent to the Queen in Council in the UK, and within 2 years, the Queen acting through the Privy Council of receipt of the law, within 2 years of the receipt of the law, has the power to disallow the legislation. So once that is done, the power abates, or the legislation abates, as it were. Now, like I said, there is also the dominion disallowance. So dominion disallowance refers to the power of the Governor General, who is the representative of the Queen, to also do similar with legislation that emanates from the provinces. And what do I mean here is basically that the provinces also have their own legislature. When they make laws, the law comes into operation, but they have to pass the law to the Governor General, who has the power to disallow that law. Okay, within a year, though, rather than the imperial one, which is within 2 years, within a year of receipt of the law. If they don't disallow within a year, then they can't disallow it thereafter. Now, the significance of this dominion disallowance is actually adumbrated by Justice Crockett in 1937 decision, in which he stated that if an enactment is such is of such a palpably unfair character as to offend the public conscience, the remedy lies not with the courts of the country, but with the people to whom the legislature is responsible. Or, and this is where I'm interested in the power of disallowance, the responsibility for the exercise of which the BNA Act has placed in the hands of the governor in council. In Canada, the power of disallowance has been, understandably, from the fact that Canada is now deemed, or has been deemed from the late 1930s as an independent country. Its independence has been something that did not go in the way the African countries go, by an agitation and a declaration and a severance of ties, but through certain culmination of certain constitutional acts. But it deemed it an independent country with a queen in her right to our territory in Canada as Queen of Canada. Now, it's a little complicated thing if you are from a Commonwealth African country background to understand this, but it just means that the Queen is, for all intents and purposes, the head of state of Canada. And that is separate from her being head of state of England, or of head of state of the United Kingdom, as it were. So there has been a debate on the current status of the power of disallowance in Canada. A number of leading scholars have argued that it is now informally amended out of the constitutional text, that its role has been overtaken by judicial review, whether partially, even completely. In fact, a notable leading Canadian scholar, Hogg, has stated that it has probably been nullified by convention. So there is those lines of argument. But my position and the standard traditional view that is now contested, howbeit, is that the power subsists in Canada because there has been no amendment of the Constitution Act, which has been amended in a number of ways after it's been passed in 1867. But that provision is still there. The Queen still has the power. The Governor General does have the power, even though that power has hardly been, was last exercised in the late 1930s. In fact, in the middle 1940s was the last time it was actually exercised. But it is part of the Canadian constitutional landscape. And one incident recently brought that to the fore. That incident was that Quebec passed an so-called anti-religious symbols law, which was to ban some public sector workers from wearing religious symbols at work. Muslim women, specifically using hijab, were deemed to be the major target of this law, as it were. But that's not the focus of the talk today. The main point here is that law led to some calls on the federal government to disallow it, that the Governor General should disallow it, raising the point that the law, the constitutional landscape still recognizes the power of the federal government as contained in the Constitution Act 1867 to disallow laws made by the provinces. It wasn't disallowed, but that became an issue as lately as 2019, after decades, raises for me that interesting point about the nature and relevance of the power of disallowance in the Commonwealth, and even in developed ones like Canada, as it were. Not about the United States. I'm going to be looking at it too. A lot to say about the United States because of the powers of the US president to veto. But that is not part of my webinar today because of time. So the last major point I want to talk about is whether disallowance. Is it something that should continue and should be enhanced, or is it something that should be done away with? My instinct, like I said, is that it should be done away with, but we'll see. At this point, I just want to throw some of these facts out there. There are jurisdictions which either never had or have done away with the power of disallowance. The absence of power disallowance here, I conceive it in the broader context of another analogous power, which is the power of assent. In some discussions, they can be the same thing, but essentially they are actually different. But the impact of them at the end of the day, whether it's disallowance or power of assent in the application, is that it can lead to what is already a law or what is a bill that is just needing a formal promulgation to actually be caught in their tracks, as it were. So I have 3 examples to throw up on this issue. One is Tuvalu. Maybe we all have heard of it, and I hope we have. And if we haven't, maybe we just want to check where Tuvalu is. Well, it's a small place. But notwithstanding that, Section 86(2) of the Tuvalu Constitution of 1986 provides that when a bill is presented to the head of state, when a bill is presented to the head of state for assent, the head of state shall promptly assent to it. So this is one primary example that negates a discretion in the head of state to do anything but sign a bill that has been passed by the legislature. So that has effectively prevented the exercise of disallowance either directly or indirectly through the withholding of or refusal of assent. Now, it is just of interest to point out that Her Majesty the Queen is the head of state and sovereign of Tuvalu. Okay? So whereas in theory, Her Majesty could refuse to sign a bill into law here, though I said the last time that happened was in 1707. But in theory, convention has more or less negated that. But in theory, she could, but not in Tuvalu. That's an interesting fun fact. My second example is St. Vincent and Grenadines. St. Vincent and Grenadines, I believe we also know that it's a small island also. And Section 43(2) of the 79 Constitution of the St. Vincent dispenses with royal disallowance and discretion of the monarch in assenting to bills, because the monarch still remains the head of state of St. Vincent and Grenadines, and that monarch is the British monarch. When a bill is submitted to the Governor General for assent in accordance with the provisions of this Constitution, he shall signify that he assents. I just noticed that it wasn't considered that a woman could be Governor General. Anyway, I think that they mean he or she shall signify that he or she assents. Again, pretty much like the Tuvalu provision, negating disallowance. The third example is New Zealand. Now, this is a little more complicated, yet in some ways, there's been major advance there. And that major advance is that the power of disallowance has been removed altogether from the constitutional arrangements of New Zealand, as it were. But still, the power of assent subsists. The power of assent subsists and is still vested in the British monarch or the representative, that is the Governor General. Sections 15 and 16 of the Constitution Act 1986 of New Zealand as amended, however, suggests that that assent is not discretionary. But that's my reading. I'm still going to hope that I will find a judicial decision on how that power is interpreted, or it should be understood. But my reading of sections 15 and 16 of the Constitution Act 1986 of New Zealand suggests that it's more or less like the Tuvalu situation. So I'm concluding with these two questions for my audience. Very unusual, but just forgive me. It's unusual times we are in. What, if any, is the system in your mind, to your mind, or policy design of the disallowance of legislation in contemporary practice? How does it compare with the imperial application of disallowance? Are these things we have talked about? Do you know of any works on them? In which case, I will be very grateful if you can write me, if you can point me at them, or just generally, what are your thoughts about this issue of the power of disallowance, as it were? And therefore, if you are interested in any of the references I've made in my presentation, I've tried to capture them all there. Back to you now, Chair. Thank you for your attention.
Well, thank you very much, actually, Hakeem, for a very enlightening and enriching paper. I've very much enjoyed that, and I have a huge number of questions myself that have occurred to me as you went through your presentation. We do, though, have some questions in the chat, in the Q&A, and I wondered if once you had had an opportunity to refresh your throat, as it were, if you would like to address any of these questions, please.
Thank you. Yes, Amy, you've asked, thank you, that a vestige of the POD is in the presidential veto powers. Would you agree that another vestige is in the power given to constitutional courts to review laws? No, actually quite the opposite. As a constitutionalist or aspiring constitutionalist, I would very much I very much subscribe to constitutional courts playing that role. My major grounds here, I know where this question may be coming from in terms of the argument as to the legitimacy of few judges or few people sitting over decisions that have been or legislation that has been made one way or the other by the people's representatives. I understand that, and just looking at that, basically, it would sound like, yeah, that's also a representative, but I beg to differ. There is literature on this, and some of them even empirical, in terms of the need for this check and balance in the way that the judiciary holds out a different approach from the political branches. How be it that this word political branches, you look at it in the United States, it can be said that the courts are actually very, very political and should actually in some cases be deemed part of the political branches of government, in which case there is no non-political branch of the three. But I'm talking about the more, conservative approach that we have within the Commonwealth at the least. And it is that the judiciary should be a counterfoil to the political branches, which will include the executive and the legislature. And actually, in so many instances, especially in the kind of examples we've had to look at on issues of discrimination, human rights, and all of that, and the rule of law, the constitutional courts have held out a fresh breath of air that would have been quite problematic if they don't have such powers for minorities, for people across the spectrum, from people who have to confront political power and all of that. So yeah, I don't consider them to be part of a veto at all. No, I don't. Judicial review is something that is crucial to democratic practice, as it were. Second question. So thank you, but it's something that now that you flagged it up, I actually have to address somewhat because it's very germane. So I recognize that. Thank you very much, Amy. The second question is, as a student interested in the topic, do you believe there is scope for research by postgraduate students on this topic, especially on the role of constitutional courts? Well, these are I'm a little confused, and the way I understand this question is instinctively yes, but the first part, that's why I'm doing this. I would be very happy to have 2 or 3 PhD students with a funded project, and I'm actually looking to get some funding for this project. With a funded project, taking on different aspects of this issue, as it were. So yes, but if you are talking about the other side of the spectrum, which is about the role of constitutional courts. It depends on what you are talking about, but I think there has been quite a number of research work going on the nature and role of constitutional courts, but there's still scope generally across the board for examination of the work of constitutional courts. Probably it will be on specific areas anyway, but yes, and I personally love such research, as it were. The next question is by Dr. Okoye Adaize. So let me just be upfront. Ada is a friend, a long-standing friend. Thank you for joining, Ada. Is it possible to have power of disallowance ascribed to a supreme body rather than person? Good question. Something to think about, really. But I think that is probably what the constitutional courts are for. Already, they are a committee of people. There are levels of the courts. There is opportunity for appeal. So they do constitute that. They are independent and their decisions hold. So in a way, I'm not sure I'm looking for some executive group to do this. Or no. The courts for me represent that. The courts for me represent that. Especially a constitutional one, or one that is a general with constitutional powers. Could it also be ascribed a more specific set of criteria, such as principles of fairness, etc., than interest? Well, this is what I want to find out. First, what in practice has been the nature of laws that have been disallowed in post-colonial systems, either by refusal of assent or by veto of any sort. That is something to first discover. I think interest will not be, well, it remains, I don't know, but I don't think any of those who are vested with those powers was on the basis of interest. No, I don't think so. I suspect that I have seen some responses. So in Nigeria, for instance, where the president has refused legislation, he is bound to write back to Congress to state his refusal. And usually what is at play there is reference to some existing law and how that contradicts that law, or it's in contradiction of some constitutional provisions or powers that inure to the executive and all of those things, as it were. So I don't think it's interesting that way of the colonial one, but even though this is a precursor to it, but broadly speaking, maybe it is actually. But I don't have a final answer at this point. But my instinct would just be, it shouldn't be a political thing, and it shouldn't be in the hands of an executive authority. So to that extent, again, I will be expecting those issues will be matters for the constitutional court, for the judiciary. Andrew, yes, thank you, Andrew. Could you just explain again, please, how the chartered companies first introduced the POD into North America? Many thanks for excellent. Okay, thanks, Andrew. Yes, basically, the chartered companies established. The chartered companies established territory. When I mean established territory, they took over territory, as it were, in North America specifically to start with, as an example. And they were assigned specific areas in their charters to expropriate. And they did, the way they operated was that they sent a few people there to those territories to administer them. But they have bodies of shareholders and governors. They were companies. They're the first multinationals based in London. And when laws are passed in those jurisdictions, they require that it be sent to them for their approval, for their review and approval to ensure their investments and their control are protected. So that's how they introduced it. And it specifically said, just that I didn't have the time to look, but you could look at section 56 of the Canadian Constitution as an example. You will find the framing there of how the law is meant to go back to the monarch for review. And what was substituted was basically, in place of the Queen, it was to the governors of the commercial companies. So that was the way it was framed. But were then adapted with their names, the governors of the companies being substituted with the Queen or the King, the monarch, as it were. I hope that is clear. If any of these my responses generates further queries from you or from any other person, of course, the chair, I hope, is open to you responding further. So thank you. I think, no, sorry, that's not all the questions. There are still two more. Yes, Dr. Enochong, Laura Stella, thank you. Could you consider POD a form of negative constitutionalism? And does POD have a place in contemporary constitutional practice? The first part is easy enough to, the second part is easy enough to answer. It is just precisely the reason that I'm doing this research, i.e., if you are asking an empirical question, yes, POD is a large part across the Commonwealth. Very few, whether it's Australia, whether it's Canada, whether it's New Zealand in its limited form of requirement of assent, whether it is Gibraltar, which has removed POD but still has assent, whether it's Nigeria that has the veto, whether it's the US that has the veto, whether it's the Hong Kong basic law as was constituted. I don't know if there has been a change. POD does have the place. If it's as a reality, it does have a place. It is in so many constitutions across the Commonwealth. It is there. It is there. So, but if your question is, should it be there? That's precisely what I'm examining. That is actually that is exactly what I'm examining. So, my instinct is no, it shouldn't. But that has to be in the context of a socio-legal examination where I hope to speak with legislators. I hope to actually go to the legislative congresses, house of legislatures across these jurisdictions and check on the records over a period of time of what was vetoed or not by holders of the power of assent, whether there is a pattern to it, whether the change of government, whether the ideologies or political ideologies of the government in power had an influence, and whether the outcomes will have been different. It's a very wide thing, but I hope to speak to people, not just lawyers, but public commentators across the spectrum, and even former and serving legislatures, about how they feel about it. So that will help me to come up with whether we would see it as something that should have a place in contemporary practice, given the dynamics of democracy, representative governance, human rights, and all of that. But it's existing. Whether it should continue to exist is what I'm really after here. And anyone can pass on to me about it in their thoughts as you are passing here, it will be appreciated. Would you consider it as a form of negative constitutionalism? Well, I don't know. I don't think I subscribe to the idea of positive constitutionalism, and so there's a negative constitutionalism. For me, there may be, unless you mean by some form of restriction on representativeness, as it were, then it will be a negative one. That's actually my point. But as to whether constitutionalism is positive or negative, maybe if you can send some further comments on as to what that means, I'll be able to have a better picture. But I'm sorry, I would only think it's antithetical to representativeness. Yeah. So, Jonathan, yes, thank you, Jonathan. Is there a distinction between unitary states on the one hand and devolved or federal jurisdictions on the other? Those are some of the issues I would like to see. But off the top of my head, so the United States is most of my candidates are actually federal states. Most of my candidates are actually federal states. And I've not seen a qualitative difference on the application. Australia has a unique situation, and there's a professional colleague from Australia listening on here. I have not actually gone too much into it, but the Australian one has a fascinating application of disallowance, which is not which I've not talked about, but which is actually not something I'm bothered about here. They have this one I'm looking at, but they also have another one which is a unique one, where an executive body or power is allowed to make delegated legislation, but Parliament has a period of time to look at legislation and disallow it. I have no problem at all with that. I have no issues with that at all. For me, that's just in order, as it were. And it helps me to actually use that frame in the Australian one to question whether that is not what disallowance should be about. But as to your question as to whether there is a qualitative difference in unitary states, now you've usefully highlighted something I should be thinking about, because I really didn't of this fact of unitary stroke federal. By some accident, my states of focus are all in one way or the other federal. Well, maybe save for Gibraltar, which I don't know if you can call the territory unitary or federal on its own, or as an overseas territories of the United Kingdom. But maybe I need to actually make sure I include such a jurisdiction in my study. Thank you very much, Jonathan, on that point. But I at this point, I don't know. I don't. Does it follow that unitary or upper tier legislators should be treated as autonomous, but lower tier legislators need to ensure that their legislation does not conflict with the overriding constitutional provisions? Let me try and understand that. Should be treated as autonomous, but lower tiers should need to ensure that the legislation does not conflict with the overriding. Oh yeah, now I understand. I'm sorry if I'm confusing in any way in my presentation, but this is not about upper tier or lower tier parts of legislatures at all. This is about something that has its origins in, like I said, colonial arrangements, where the imperial, that is the British monarch, and the political system and the legislature is deemed superior to the colonies. That is the stuff of political reality of colonialism or colonialization. So no problem with that. But in terms of post-colonial countries, it's that sort of arrangement doesn't stand. It has no place in it. So I'm not sure if I've answered your question. But if I extrapolate with the Canadian experience, which is quite unique, what is actually known as dominion, imperial disallowance is very clear as to what it means. This is the monarch in England, the colonizer government is superior to the Canadian legislature, is superior to the whole of the Canadian political system, because the sovereign is here. And on that basis, there is clarity on imperial disallowance for the whole country. Laws made by the federal government, or the Dominion Parliament, as it was formerly known. But the provincial disallowance is premised on the federal arrangement, ostensibly. But ostensibly because it said that the Governor General is able to assess the overall interest of the country as against a provincial legislature. And that is why that power exist to ensure that there is a balance maintained in the overall interest of the country as against a province of the country, because there is a lot of background to that. Canada did not come together in the way the US came together, as it were. There is Quebec and all of that, Lower Canada, Upper Canada, not talk about new provinces that joined later, but that is the premise. So it's like a federal power, as it were. But if you look closely at it, the Governor General is actually an appointee and representative of the Queen. So it's imperial. For me, it's imperial disallowance in another form. And it is actually the application of this provincial disallowance that was the most topical in its application in Canada, just as the recent event in 2019 brought up, like I said. So I'm not sure if I've answered your question fully, but I'm sorry if you need that clarification. You can send further. Yeah, you have sent further, actually, Gilmerton. Gibraltar is an overseas territory, and in that regard, it operates as a lower tier in constitutional matters. Research on this issue will be very useful. Oh, I'm happy to tell you that I'm actually a legal advisor on constitutional matters to the government, or Her Majesty's government on Gibraltar, and I've done extensive work. And there's a report which I'm not allowed to share that I've done as part of a research project for the government of Gibraltar on its constitution, and it's still an issue in process. So I can't say more on that. So, but in terms of it operating as a lower tier, I've actually written 2 articles recently on this. And if you're interested, Jonathan, I can send them to you. My email is h.yusuf, yusuf@derby.ac.uk. If you're interested in following up on that aspect of the constitutional arrangements of Gibraltar vis-a-vis the United Kingdom, I have actually 2 published recent works in 2019 on the topic, and I can send them to you. We also ought to look at the way in which devolution works as a lesser form of federalism. I agree. The Devolution Acts in the UK allow for oversight by the Supreme Court as a form of constitutional court. Absolutely. Yes, I agree with all of that. But there are issues that are only tangential to my focus on disallowance, if you know what I mean. I would be looking at how or not the monarch in the UK can today refuse to sign or assent law that has been passed by Parliament. That is something that has not happened in over 200 years in this country. It's not happened. Simply, it's just not. Convention is theoretically the power still endures to the monarch, but it's not been exercised and is deemed to have gone into desuetude. It's atrophied, as it were. But that's the part that is still alive and well in relation to Gibraltar, through the refusal of assent, as with in differing ways to the other 14 British overseas territories, as it were. And that is a separate issue from a constitutional review. There are quite a number of issues and cases around this in recent times. If you are interested, I am happy to send to share what I have on that with you. But like I said, that is all tangential to my interest narrowly in disallowance at this point. Thank you for all your questions. Chair, you do have your own questions.
Yeah, I do have questions, and the chair on this online platform has a very real privilege, which she can speak and be seen rather than having to type the question. So I'm going to exercise that privilege now. Hakeem, one of the things that struck me as you went through your paper here, I'm not at all surprised that you find a similar power of disallowance rolled throughout what's now the British Commonwealth. Lawyers and legislators are great borrowers, what amongst our students we call plagiarism. And I think that part of the reason for this is actually just laziness, that we need to do this again. So go find what you did before. And I suspect if Lauren Benton's thesis is correct, over time, there's suddenly a concern, actually, that maybe this empire ought to be run on a similar basis. And so bits are snipped out and applied elsewhere, or clipped in the interest of consistency, so that it's not simply just, laziness. So one of the stories that I think you have going on here, I suspect, is how lawyers not only borrow bits of institutions, but also how those institutions are later adapted to local circumstances. So you're quite right. The Canadians have their own series of, controversies and challenges over this power of disallowance, which part of it is the federal structure, and there's other elements going on there. So that what you have is a story of the adaptability of legal institutions. And from that, I wonder, to go to your larger point about, where does this power of disallowance fit in the modern sort of liberal world and in a democracy? And it seems to me that a lot of that question depends on the purpose for which the body or institution who can exercise the power do so. So I think that you're right when you indicate that at the outset of your presentation that, colonies are a subordinate portion of empire, and you necessarily have to have control from the center to disallow things that you don't like. And sometimes this is, I think, for very rank imperial reasons. I think in other instances where I've seen, I think in colonies this happens because somebody at the center realizes that actually if this colonial legislature does this, it's likely to cause unrest in that area. One of the things about the British Empire, this is an empire, you're quite right, built with the rule of law, and law is a controlling instrument, but it's also a mercantile empire. So you need to have control in order to have trade. If you don't have peace and order, you have no trade, and that defeats your entire purpose. So, at one level, the British Empire isn't attempting to save people's souls. It just really wants them to trade on a level platform. We could extrapolate more to that, to our current situation, but that would be overtly political. So I'll resist that. So really, to me, one of the things about this is who exercises this power and what ends do they serve? So you spoke about the Canadian example about, the conscience of the people and so on and so forth. Quebec is, because of its very different heritage and its different religious and linguistic and legal bases, it is always, I wouldn't say an outlier, but I always think of it actually as the sand that makes the pearl in Canada. I mean, if you compare, say, Canada to Australia, the presence of Quebec makes Canada different in various ways from Australia. So something like the Religious Symbols Act, one of the things I think in a modern constitution that might bear examination is what's the interaction? I don't know what the answer is. What's the interaction between, say, the power of disallowance, the federal power of disallowance, and the ability of Quebec to pass legislation that would, on the face of it, appear to contravene the Charter of Rights and Freedoms, and yet the Charter of Rights and Freedoms, as many people will know, has except an overriding clause that you can enact things that, as the Canadian law is, as long as in your enactment you say that you realize this offends or has the potential to offend the Charter of Rights and Freedoms, say freedom to religious belief, if you say that notwithstanding this, you intend to exercise it, do you end up, in other words, with the power of disallowance in a liberal state being used for human rights, where a state's own provisions for human rights might be disabled?
Exactly. The example of I agree with your submission. The example of Canada, though, is actually very apt, and I suspect will occupy, as the former project I did, an undue proportion compared to the other jurisdictions of my work. I would say that what the current, what scholarship on Canadian independent status suggests is what I hinted at, that in in the where there is this sort of challenge posed by the Quebec anti-religious whatever symbols law, the courts are adequately, the Supreme Court, especially in the Canadian system where they have the system of reference, are well placed to address the concerns on equality that is thereby generated, and that to take care of it, and there have been quite a number of cases to take care of it, of such constitutional concerns as those in the Canadian Charter on rights. They should be matters for judicial review rather than matters for political decision making. I see the wisdom in both. I am against executive power being used for disallowance still, but I see the wisdom in the way that will just nip it in the bud quickly. But we have to remember that, especially in the kind of example that you have pointed out, Quebec and its special features, and the long-standing difference between it in certain ways and its English neighbors in Canada, which got to a point that they wanted secession. It will be better, in my opinion, it will be taken to be better for the rule of law to be seen to be, and human rights to be enforced through the courts than political action. Not the least because there may be a political, as is the case in reality, a political situation where the party in power in Quebec, in the province, is ideologically different from the one at the center, and then it's seen as an ideological political power tussle rather than the higher values of human rights, of constitutionalism, of democracy, of participatory governance, of dignity, and all of that, and international values that are important. And that can lead to political violence, political tension that are undue. But if it is a judicial institution, there is still that ostensible neutrality that gives it legitimacy. So to that extent, I would think that the better way would be to have taken it to court rather than call on the Governor General to exercise a power which may lead to unrest, especially in these days of populism, as it were. Especially in these days of populism. That's my thought on it. But everything you said has just spot on in terms of how the system has developed, how it was used in practice. In fact, when you said that it's just lawyers being lazy, it's not just lawyers being lazy, actually. You are just absolutely on point. It went to the point that people will be moved from one part of the empire where they had applied a certain policy to another one when the need was sought for addressing what has come up there. Lugard was somewhere else. What he did there, he was brought to Nigeria, and the laws he used there was brought onto Nigeria, for instance. And that is not unique. It's something standard across the empire that happened across. So not only were laws being used and copied in that way, Queensland's criminal code was adopted in elsewhere in Africa and India, and then it was then brought to Nigeria and all of that. But actually, in some cases, the purveyors of that policy, of that document, of that legal instrument were actually moved to the new location in empire, which then meant it was believed that more or less of the same could be applied elsewhere. It was cheaper, it was pragmatic, and all of that. So.
Thank you, Hakeem. And I agree, the British Empire had not only free movement of goods, as it were, but both the free and forced movement of peoples as well.
Absolutely.
if I'd like to pause just for a few moments here to see if anybody else would like to post a question in the Q&A.
Yeah.
I recognize that probably many of you, like me, didn't start life in your academic career thinking that your typing skills were going to be of paramount importance. So if we wait a few moments, if anyone would like to raise another question in the Q&A box, please. While we give people a moment to do that, something else that I had been wondering, Hakeem, this is just a way of sneaking in a second question, you see,
Okay.
that is the extent to which the exercise of the power of disallowance is or is not reviewable, and what judicial body it is reviewed by may also, help to understand quite how it's used. And I'm thinking of that, beginning in the sort of 18th and then into the 19th century. So something like the relationship of, say, the Judicial Committee of the Privy Council, to the Crown. I mean, you have sort of two different exercises of Crown prerogative, I suppose.
Yes.
Yes. And the extent to which, for want of a better term, disgruntled colonists might try to seek to, in many of the cases that I'm sort of mentally thinking through about disallowance here, there is often a faction within that colony that doesn't want the legislation. And there's a sort of political struggle to get that, to London, to say, look, we don't want this and this is a problem. But then, there will be another faction that actually really wants that. And so, something that might be illuminating or helpful in your study is to think about how the mechanisms, formal and informal, for the review of the exercise of this aspect of Crown prerogative might work. I have no answer to that. It's just something that
very, very, very useful. It has exactly the situation you described. The situation you described as actually being the experience there, and I would look further closely, but my initial research suggests that there wasn't such. The Privy Council in its the Judicial Committee had no role absolutely in this, as it were. What happened in reality in the scenario you painted, which was very common, and both sides used what they got on this, was that they went back and made the laws all over again, or they made the laws a number of times and then said it was temporary. So there was that, and it was recognized as a mechanism, as a stratagem to bypass what they knew would be a disallowance, as it were. So there was resistance. There was resistance at play, as it were. But in terms of review, in the historical context, there wasn't, except that they went on, as even some of the examples I've mentioned to you, they went on to make the law again. In some cases, they kept doing it for the next 5-10 years, because then what it meant is they've done it. So it doesn't work like 2 years they'll be back. Most of the provisions required 2 years, but they will not be back. There were instances where they never got back to them until 12 years on the same on a law that had been in operation. London didn't get back. It wasn't a very efficient system. All of that I can't talk about here, but there are issues. All of that. But the thing is, even in those cases where they got back supposedly efficiently within 2 years or something, or within a year, they went on and made a new law, and then it goes back, and then they go and make a new law, and they try and cut it up and down and stuff like that. So there was resistance, and that resistance is interesting because it also talks about the resistance. It speaks to the issue of what is done now. In the constitutions I've looked at, I don't see a review mechanism. I don't see a review mechanism, but it's interesting to study and find out what the legislature or Congress or Parliament do when there was refusal of assent with the law. In some constitutions, there is actually a cure. The cure is that, okay, so there are two ways. You can just passively refuse to assent, and after a particular number of months, like in Nigeria, maybe 6 months or something, then if it will lapse, that law will lapse except it is picked up. The power of assent would have meant that the law will lapse when you don't assent to it. You don't even give your refusal, just ignore it, which is quite historical in its practice. But in the Nigerian Constitution, as an example, they have a right, because the Congress has a right at that point to pick it up and pass it all over again, or in some cases to actually override the absence of assent and then make it into law, which is an interesting thing. But it's not every system that has that, and certainly the former Dominion countries don't have that provisions. Where they have still retained assent, they don't have that provision. So it's a wide field, really. I think I've just thrown myself in front of a moving train, this one, but we'll see.
So thank you very much for an illuminating and interesting presentation, Hakeem.
Thank you very, very much. Thank you all. I know these are busy times, and I'm very grateful for your attendance and your contributions.